step into a new venture, which is to try to provide some CLE opportunities at most of the home football games. In 2 years, I figured out that that's when we see the most people, and so we thought we would see if there was an interest in CLE opportunities. And our first two volunteers, in addition to Professor Gell, who will be doing the ethics portion in a moment, are Tom Long, a very distinguished practitioner and a graduate of the University of Wyoming, though not of the University of Wyoming College of Law, but he's managed to overcome the deficiencies of a Harvard Law School of education. And Professor Jim Delaney, who many or all of you know as an outstanding tax and trust estates expert. So I'll get out of your way and please.
Thank you. I'll be the first to speak. We may interact a bit between Professor Delaney and myself because we're both talking about primarily the same subjects. By way of a little further introduction, I'm with the firm of Longheimer, Weninger, Beppler. I'm in our Cheyenne office. I've been involved with the LLC legislation since the issuance of Revenue Ruling 8876, which opened the door for LLCs to be taxed as partnerships. One of the curious things we'll be talking about today is how we favor reversing that in some cases and causing them now, although by default they're taxed as partnerships, now sometimes we want them taxed as corporations. So that will be part of the presentation. Professor Delaney has been on the faculty here, as you know, for about 8 years.
Yes, that's correct.
8 years. Teaching tax, including partnership tax. And what you will be hearing, the kibitzing that goes on between us, he will be giving the tax side of some of the things that we're going to be talking about. I'll be covering more of the state law side of things. And then, of course, the best has been saved for last, Professor Delb, who, by the way, not only went through Harvard Law School, but was on law review. Isn't that correct, Professor? Do you admit to that?
I did.
And Harvard undergrad, and has blessed all of us with his presence for at least 30 years.
That's right. I don't know about the blessed, but
and so those of you who want your ethics credits, we are going to make you wait and sit through the rest of the program if you're too good. All right, so starting with the state law side of things, I'm not going to give you a whole lot of the history of it. As between Professor Delaney and myself, I think we're only going to try to take about an hour of time. I think Professor Dell, we're leaving you an hour. I hope that works for you. In lieu of telling you all about the new Wyoming Limited Liability Company Act, let me just mention that there is a nice article in the 2011 volume 11, number 1 issue of the Wyoming Law Review, which has a very lengthy discussion of what it is, how it's changed, why it's not quite like the old law and not quite like the Uniform Act, which is sort of the chassis on which it was built. So the Uniform Act will provide a fair amount of guidance for Wyoming limited liability company questions, but as the article calls it, there was a fair amount of home cooking with how we drafted the Wyoming Act. And I was one of the parties involved in, there were lots of committee meetings and studies and lots of testimony in front of the legislature that led to this new act. So one of the reasons I'm here is I know where the bodies are buried with this new law. The highlight of the new law, I would say, is that Wyoming has opted to go with what the drafters of the Uniform Act pejoratively describe as the ultra-contractarian approach. I never knew there was such a word, but I'm guessing what it means is we're far too contract-based with the structure of this type of business entity to please the draftsmen of the Uniform Act. The derogatory term, in fact, was initially pointed at Delaware. To some degree, I think they may feel we have out Delaware, which always is a temporary phenomenon, by the way. In any state that tries to out Delaware, in the end, gets passed by Delaware. So, for now, we do have some provisions of Wyoming law that are not found in the Uniform Act or Delaware law. Along the lines of this ultra-contractarian approach, I would mention one of the bigger differences is the waivability of fiduciary duties under Wyoming law. You basically can design your LLC to have whatever ownership rights you want the owners to have, whatever management rights you want to bestow, sliced vertically, horizontally, diagonally. You can structure it as you choose, and hence the contract basis for the criticism of it. Other highlights for what's different under our new act, the filing differences involve, you no longer have to say you're making a flexible election, and I'm wondering how many articles of organization still show up in the Secretary of State's office with a flexible election made on them. Dissolution filings are different now. Articles of dissolution are optional. So if you're on the verge of filing articles of organization for an LLC, do take a look at the statute. You don't need to name the members and managers anymore. Although there is, I think the Secretary of State is rethinking that after this article, maybe some of you saw about the business in Cheyenne, 8,000 different businesses all in one house, and some of them were up to no good, as I understand. So for now, there is an element of privacy, and that, by the way, is a feature of the Uniform Act. The no need to disclose who the members are, who the managers are, and I would hope that does not change. One of the more significant changes to the Wyoming Act is in the area of creditors' remedies. The charging order remedy has been strengthened, if you look at it from one perspective anyway. A creditor does not have a right, creditor of a member, so a creditor of an owner of an LLC does not have a right to seize the LLC membership interest from the member. What the creditor has a right to do is get what's called a charging order. Now that's not new, and that was in the 1916 version of the Uniform Limited Partnership Act, and that's what carried forward these many years for LLCs. What's different is that the Wyoming Act now clearly says the charging order is the exclusive remedy. The Uniform Act would allow the charging order to be treated like a lien that you could eventually foreclose. Under our act, the Wyoming Act rejected that approach of the Uniform Act. No liens, no foreclosures, only the charging order, and Wyoming law expressly applies that in the case of a single member LLC. The historic theory of a charging order was that you don't want to crack open a partnership and mess with the other partners if just one of the partners owed something to a creditor. So that theory has been stopping other states from protecting single-member LLCs. Wyoming sort of crossed that bridge a few years ago when it authorized the qualified spendthrift trust. So in other words, if I have some assets and I don't want my creditors to get them, as long as it's not a fraudulent transfer, I can take my assets and put them in a qualified spendthrift trust, and it's now beyond the reach of a creditor. So it was an easy next step for the legislature to say, okay, we're now going to allow you to do that with an LLC, even though it's a single-member LLC, even though there's no other partners to protect. We're only going to allow that creditor to have a charging order remedy. And that may or may not be a satisfactory remedy for the creditor, because the charging order only allows a creditor to grab the distributions that are coming out of the LLC and going to the owner. And the ability to force distributions is not part of the creditor's additional remedies. So that is new and different, and subsequent to the passage of the law, that has caused me to be receiving some communications from lawyers from other states. So apparently that is a somewhat attention-getting change.
Did you want me to talk about the tax side of that?
Please.
So there is a tax issue there, and one of the key things that Tom just indicated, I think, was that you can take a distribution, or I should say a member or partner can receive a distribution from a partnership or an LLC that's treated as a partnership. But in receiving that distribution, it's part of the decision process of the members themselves. You may or may not be able to receive a distribution, although you will be, as a member, allocated profit. So one of the issues that comes up with creditors is if there is a charging order and a creditor obtains a charging order, then they have a right to part up, especially, for example, if it was foreclosed upon. If a creditor was able to, which they are not.
Not in Wyoming.
Right. You would have a situation where the creditor actually owned the unit, and then the issue that is then, from a tax perspective, important to the creditor is whether or not that the allocation of income, the creditor as a holder of the unit, would be taxable to them. So, for example, if the creditor has $1 million of debt, or they loan $1 million to the borrower is a member of an LLC, and then the borrower defaults and the creditor is able to obtain a charging order for a substantial portion of LLC units, will the creditor then have to report the income and pay tax on the income, notwithstanding, as I just said, that no distributions might be made? And that's a kind of a hazy area at this point. There's no real answer to it. And again, in Wyoming, there's not going to be an actual foreclosure on the unit. But if there is the right to obtain a charging order and receive a distribution, there are some commentators that believe that the creditor will be taxed on the allocation of income. And there's another whole group of commentators out there that believe that that shouldn't be right. And I would say, not that it makes any difference to you whatsoever, that I tend to fall on the other side. If I were in a creditor's position, I would argue that I have no control over the partnership. I'm merely an assignee. I have no right to vote. And as such, any distribution that might come out of it would not be income to me. It would be repayment of debt, which is tax-free. So.
Yeah, and I'm in that camp also, because even if a creditor gets money out of this LLC, it really is a discharge by the debtor member of the debtor's debt. So really, it's like the debtor got the money and paid the creditor. And remember, in an LLC, it doesn't really matter how the money flows. It's just, if you're the member, the income gets allocated to you whether you get the money or not. But I think the fact that it's a discharge of debt really puts me in the camp of thinking a creditor does not pay tax just because they got a charging order.
And not only would I completely agree with that, I think if I were in a creditor's position, I would argue that the actual individual that borrowed the money, would have to report the allocation of income, nevertheless, on partnership income.
Now, the creditor may, if it's a debt with interest, the creditor may have to treat part of the receipt as interest.
Absolutely.
Maybe the debtor gets an interest deduction.
Additional tax consequences.
Right. back to what's different about the Wyoming Act, and then we're going to get into some of the how are we using it. Actually, I'm only going to get into a couple of the how are we using it. If you all have this paper, while Dean Easton is here, I'll mention him. So on page 7, you see items V1 and V2. See, that's where the paper started getting long and started running out of time. I called Dean Easton and I said, I need a raise. I'm not getting paid enough for this. He said he quadrupled my pay, and I said, that's still not enough. So these points are really what we're tending toward, and you're mostly going to get a verbal discussion of how we are using these LLCs for this purpose. But back to, before we get there, what else is different about LLCs and what might make us want to start thinking about them differently? Before we finish creditors, let me mention the reverse veil piercing. An overall comment I'd make about how can creditors crack open an LLC to get at the creamy assets in the middle that will pay the creditor what is owed by the LLC owner. And there are really three things they can try to do under current law, under pre-new LLC Act law. One would be the charging order as it was, which had more power to it before the new act. Another was fraudulent transfers. They could claim those assets never should have been put into the LLC in the first place. And then the third is one that maybe most of you have not heard about, which is called reverse veil piercing. We don't really have any Wyoming cases on it, but there are lots of cases from other jurisdictions where, in effect, a creditor was allowed to get inside an LLC and take the assets out of it under a theory very much similar to piercing the corporate veil, only in reverse. So the sort of commingling, you didn't keep your minutes up sort of theory. What the draftsman of this new LLC Act did was try to limit that remedy to some degree as well by changing the wording in the Uniform Act, which had said the charging order was the only remedy against the debtor and the debtor's interest in the LLC. The Wyoming statute, if you take a look at it, and it's 17-29-503G, the additional wording says that it's also the only remedy available against the asset. So not just against the debtor's interest, but against the assets of the LLC. When that was presented to the legislature, it was pointed out to the legislature, this likely will inhibit reverse veil piercing, and they passed it anyway. So that remains for some judge to ultimately say, but I think maybe that also is an additional protection that a debtor would get under the Wyoming Act. A couple of other just different points that are very different from the old Act. The nature of the interest that is owned in an LLC is now more clearly defined. We talk about membership interest, but the new Act breaks it down into what a subcomponent, which is called the transferable interest. The transferable interest is basically what I would describe as the economic rights of an LLC membership, the rights to get distributions, the rights to get your money back when the company wraps up. Those transferable rights now are a little more clearly defined, and one question has been answered from the old law, which was when a member transfers their transferable interest, what happens to the rest of the interest? See, in the LLC membership, is I always tell my clients, because this is kind of hard to grasp, but I say it's a bundle of sticks. You got your right to the profit stick. You got your right to get your capital back stick. You got the right to look at the book stick. You got the stick that says you consent to other people's transfers. There's maybe 20 different sticks if we really slice this as thinly as we could. So what happens to those other sticks when you transfer the transferable interest? Under the old law, I'm not sure we do. Under the new law, what it says is they stay with the transferor unless you provide otherwise. In truth, I have to tell you, under the old law, I thought they disappeared. I didn't know where they went. But the new law makes it very clear they're still there. And so somebody who thinks they sold their interest, if all they were able to sell was their transferable interest, which, by the way, is all they can sell without consent, they're still a member, and they still have voting rights. They just don't have any economic rights. So that has changed, and you need to be attentive to it. And then the other change that I tend to hear about a lot is the default rules on how distributions are made. Jim and I have talked about the difference between distributions and profit allocation. The Wyoming statute says if you fail to provide in an operating agreement, and an operating agreement can be verbal, so if you fail to have any agreement whatsoever on how you're going to make distributions out of this company while it's in existence, the distributions are going to be even Steven. They will be per capita. So if one person puts in 100% of the money and the other person puts in nothing, they're still going to take distributions 50-50 unless they have provided otherwise. Do you want to speak to that and how that impacts?
Yeah, if I can go into some of the 704B stuff and then drop into what you're asking.
Please, well, maybe we shouldn't do that. This could get pretty thick, but the weirdness of the statute, let's talk about that. The statute says that if you don't have an agreement, look at the tax return and see what you did on your tax return. But the weird thing about that is the tax return has two things. It has allocations of profits and it shows withdrawals, which are distributions. So which part of the tax return do you look at? I think the legislature was thinking, look at how you're dividing up profit allocations and treat those as distributions. But then that creates all sorts of tax issues, doesn't it?
Yes, it does. And I still want to go into 704B, but I'd like to. So here, there's a rule under 704A of the code, in the Internal Revenue Code. And it effectively says that you can agree by agreement. I mean, I think that a lot of practitioners, and I have a pet peeve about this in the local vicinity myself, and for those of you who may or may not know, my wife is a CPA in town, so she often does tax returns for a number of partnerships. And 704 authorizes special allocations by a partnership agreement. You all probably know that. That's one of the benefits of having an LLC, is that you can specially allocate. And 704A specifically says you can do that. However, 704B says that special allocations will not be respected if either the agreement does not provide for them or it doesn't have substantial economic effect, meaning the allocations themselves. We'll get to that in a minute. But in this part here, the operating agreement does not provide for special allocations. That would also be where there is no operating agreement. And really, I mean, how many people have seen a situation where a group of people agree and don't either A, write an agreement, or B, write an agreement that's so short it doesn't say anything about anything. And that's the situation you're in right there. I think you dropped into 704B. Economic effect is the other requirement. And there's really, without going into all this in detail, which Tom doesn't want me to do, but the partners, in order to be able to, and this is what I think a lot of lawyers don't understand in Wyoming, in order to be able to have a special allocation, you must have these three things in your agreement, or the IRS will not respect an allocation. And that means the partners must maintain capital accounts in accordance with regulations. There is a body of regulations that tells you exactly how to maintain capital accounting. Number 2 says on liquidation of the partnership, Liquidating distributions are required to be made in accordance with what your capital account is. Put this in perspective for your clients. I think your clients want their capital account back. 704B is based on fair market value. If you're putting your assets in at fair market value, your capital account is reflected at fair market value, and that's what your client wants back in a distribution and liquidation. I think they're tied together, Tom. I don't think you can just say distributions are X without dealing with the allocation side. And third, it says that the partner has a deficit in his or her capital account, and that can happen by special allocation. Then, at the time of liquidation, they must be unconditionally obligated to restore the amount of the deficit. That's what the last part says. Who puts that in their agreement? Nobody. Why? Because it blows the whole asset protection notion out of the water when it comes to every partner. If you're going to agree to restore unconditionally all the negative amounts, if there's any borrowings in the LLC, that will take them negative, and they'll have to restore that. So what people do is they include another provision, which is a qualified income offset, which takes care of this alternative. I'm not going to go into that, but here's the example. Here's the example you want to look at. Assume 3 individuals form an LLC. Each contributes $300 to the LLC, and this is what Tom's talking about. If each person contributes an equal amount, the members agree in writing to specially allocate, and they do it 50%, 30%, 20%. So long as you've met those 3 rules in your agreement, then you can allocate 50, 30, 20. So as long as you meet the regulatory requirements, you are allowed to allocate in any other fashion that might not be equal. All right? Now I want to know how many lawyers in the room, or if there are any that do this kind of drafting, remove the special allocation tax provisions from their agreement or never had them to begin with. Is anybody going to raise their hand and admit that? Because a lot of lawyers, what they do is they see the regulatory allocations and they say, I don't know what this means. I'm not going to put this in my agreement. And then what happens, and this is what I see from an accounting perspective in town, is they throw it at an accountant and say, we wanted to allocate 50, 30, 20. Go ahead. And this goes back directly to what Tom said. If you've got that situation and you're going to say, I'm going to allocate other than equally, and your agreement doesn't have that, then you can't. And that's all there is to it. So what's the accountant going to do? The accountant's going to do it how? I don't know. I actually cannot answer the question. If the client tells the accountant to go 50, 30, 20, some accountants will, even though the agreement doesn't say that. Okay?
Not,
and so,
not just some accountants, virtually all accountants will.
oh, well, my wife won't. Because she actually knows.
Yeah.
Now, this is what he was saying. In the new act, it says that they're going to go equally because they're going to distribute other than in liquidation or in liquidation equally if you don't have an agreement. Okay? Well, go ahead. Distribute equally, right? If they contributed 50, 30, 20 originally, then you've got a problem because equally means it is a special allocation. Right? And if the code is saying it's going to be equally, you've already gotten in trouble with the IRS because you don't have what? You don't have that. And as much as Tom doesn't like that, or as much as you might laugh at me, the complexity of that, you're in trouble. And the accountant might also go ahead and do it equally. And then they're the ones that are have to go back and amend the return to fix that problem when the IRS audits the situation. So you have to follow that example and tell yourself, I might not know what those tax regulatory provisions say in those agreements that are all out there, but it doesn't matter if you don't specially allocate. It only matters if you do. And if you're going to go in and specially allocate, you got to watch that provision, and then you're going to look at that distribution provision in the new act, and you're going to ask yourself, what does that do to me? Does that require me when it says that the tax filing is evidence of our agreement that we have special allocations? Because if it does, you're once again in trouble with the IRS.
So the takeaway, I was wondering if you were going to say qualified income offset.
I did say it in the act.
So the takeaway is you've all seen partnership agreements or limited partnership agreements or LLC operating agreements. I hope you all have seen that have some provisions in there that refer to 704C and 704B and the qualified income offsets and minimum getting charged back. Words like that you're going, what the heck is that? The point is you need it. If you're gonna have a deal where the profits aren't going to be divided exactly in accordance with what they're putting in. And that happens a lot, where somebody's, well, I'm the one doing the work, I should get more. So if you're going to do that, and it's not going to be a 707 guaranteed allocated payment, you're into 704B. So you need that boilerplate. And it doesn't hurt. So just leave it in there. Make sure the 704C refers to 7 years, not 5, in case you have some old stuff. But otherwise, keep the stuff in there. The other thing, the qualified income offset just means you're going to need some phantom income at the end, but at least you don't have to pay it back. So that's why we always do that. That's why Professor Delaney says you never see that, oh, I'll make up a negative capital account balance. Remember, A is the guy who's going to have the negative capital account because he only puts in a third, but he's taken out 50%. He's the guy who's going to go negative. He's the one who's going to eat income at the end. Taxable income with the qualified income offset. So I told Jim, let's not do this. So now we've done it. So anyway, it's some kind of thorny stuff, but the main thing you need to know is have that boilerplate in there, and when the tax returns get filed, make sure it's the accountant, not you, that is responsible.
Well, and it would be a bit relevant to say the accountant should really have a copy of the agreement.
Oh, must have. Your duty is to make sure the accountant has it so that when anything goes wrong, you can blame the accountant. All right. To finish up my state law stuff. So the benefits of the structure, primarily so darn flexible, so well creditor protected, makes you think, I want to be able to do something with this. This is a useful thing, this LLC now. At the State Bar Convention last year, we gave a presentation. I made a comment, who would form a corporation anymore? You can form an LLC and declare it a corporation. Part of the check the box. Why don't we go through check the box right now, Jim? Have you got slides on that?
Check the box. For those of you who are not familiar with check the box, one thing you'd point out is the new act requires the LLC or limited liability company be included in the name of the entity. With respect to check the box, they're under that section 7701. They dictate the classification for tax purposes of the entity, whereas the state law dictates what the entity is for state law purposes. To the extent that the Wyoming Business Corporation Act requires the corporation be included in the name, then it's going to be a corporation for the 7701 regulations purposes. In other words, you don't have a choice. If it says corporation in the name, it's treated as a corporation for tax purposes. However, if it's not a state corporation, if you don't form it in Wyoming as a state law corporation, for example, if it's an LLC with 2 or more members, and you don't do anything at all, the rules will default you into a partnership status. Okay? Now, what you get from that is form as a corporation. You are a corporation, don't do anything, and not be and form as an LLC, and you'll be treated as a tax partnership. If you're not a state law corporation, you only have 1 member, that may default then to a disregarded entity status or disregarded individual. What that means is the individual reports as a sole proprietor would on their individual 1040 for the profits of the company. But here, if you are not formed as a corporation, you're formed as an LLC, and this is what Tom's referring to, you of course have the flexibility to then check the box to make an election to be treated as a corporation if you so choose to do so.
Perfect. And then you can take the next step. The checking of the box is Form 8332.
Yeah, checking the box is on 8332, yes.
All right, and then you can take the next step and file a 2553 and be an S corporation.
Right.
So back to my point about why form a corporation. An LLC can be a corporation. An LLC offers so many other things you can do with it. It's not as rigid, and it is more protected. So the thought occurs, what can we do with these? This is a useful tool. So the 2 things that I pointed out on page 7 of the what can we do with it, the single member asset protection LLC and the LLC is a partner in a partnership. So those are the 2 things we're going to tell you about today. I'm sure there are many, many other things, but the two that we deal with often in our office are those. So let me take them a little bit out of order, and I'm just going to mention them. Jim, you're going to, I think, get into them in some depth as to why they do what they do. Let me just quickly mention them and then talk about the state law methods of trying to get to that point where you can do that too. So let's talk about the partner and the partnership. Our law firm is Long, Reimer, Weiniger, Bippler, LLP. One of the partners of which is Law Offices of Thomas N. Long, LLC. The Law Offices of Thomas N. Long, LLC is an S Corp. Even though for state law purposes, it's an LLC. So our law firm is a partnership. The partner that reflects me is an S Corp. And I used an LLC to do that. So why did I do that? Well, Jim will explain in greater detail, but primarily it's because I want to use my, what used to be Law Offices of Thomas N. Long PC, I converted it to an LLC. I want to use it as a piggy bank. And there are some advantages for tax paying and tax reporting purposes to doing that. And so that's what we're going to be talking about when we talk about using an LLC as a partner in a partnership. Typically, that LLC is going to check the box and then file a 2553 to be an S Corp. So I'm really talking about an S Corp inside a partnership. All right, the other use is a little more, I think, intuitive, and that is the single member LLC. How many of us practicing lawyers have clients that own multiple properties, real estate owners, own more than one building? A lot of times we see them put each building into a separate LLC because they want to protect one building from the liabilities of another. And so they're trying to get the classic limited liability where they want to keep the liabilities inside the LLC and don't let the liabilities get out. Well, the creditor protection we have with single member LLCs now can let you do just the opposite, protect the assets inside the LLC. And so we may want multiple LLCs as asset protection devices. And in estate planning, we may start using LLCs as holding companies, more than one, to help isolate liability and protect assets from the liabilities of its owner. So Jim will be talking about the tax elements of that. And that kind of entity is the, well, we don't have the disregarded entity page, but
this is the disregarded entity.
disregarded, okay.
Right here.
So
Only
the
one
single
member.
member LLCs that hold assets are going to be disregarded. We tend to kind of like that for estate planning because then when you die, you get a basis step up and it doesn't really cause any negative tax consequences that we sometimes deal with S Corps.
You're not going to say defective grantor of trust?
Wasn't planning on it. Well, in any event, were we going to talk about S Corps and lack of step up? That's not in your stuff, is it?
S Corps and lack of step up?
Yeah, at the death of, so if we had a single member but we made an S election with it, we would not get a step up in basis. So that's one of the drawbacks of Law Offices of Thomas N. Long, LLC. We would have to liquidate it after I die to get a basis step up. So longer story than we're going to tell you today. But the two things we are going to tell you about are the benefit of S Corp taxation inside a partnership and the benefit of the LLC as an asset protection device. So now, how do you get there? So I started with Law Offices of Thomas N. Long PC. How did I get to be this Law Offices of Thomas N. Long LLC? And the answer is I converted I filed articles of conversion to get them. So that's one of the ways you can turn a corporation into an LLC. And I'll talk about that a little bit more, but there are two other ways. And in the paper that you've been given, I actually have a discussion of the merger as the classic method of doing this. Sometimes I've seen in the literature called reincorporation. Continuance, which is another way of changing domicile. So if you had a client with a Delaware LLC and you wanted to bring it to Wyoming, because Wyoming protects it better, then you would maybe do a continuance. And the third method is conversion, which is the one I've actually used a couple of times. I've used the merger, by the way, I've used the merger method to convert an LLC into an S corp once. So it's a useful method. It works crossing jurisdictional lines. I turned a Nebraska corporation into a Wyoming LLC by a merger. And so these techniques are useful to try to get to the point you want to be, which is to have the Wyoming LLC. So merger is pretty simple. You create the Wyoming LLC as a subsidiary of whatever your entity is that you want to turn into a Wyoming LLC. You then merge the parent into the sub, and the sub survives. So there's several steps to it. You've got to deal with the jurisdiction that the parent is in and make the appropriate filings there. You have to make sure their law, if it's not a Wyoming corporation, you have to make sure its law allows merger with an LLC. Lots of states do, but some still don't. But that would be one way of bringing the entity into Wyoming LLC status. The continuance is a little less available, but sometimes if you're talking about non-U.S. entity that you're trying to bring into Wyoming and become a Wyoming LLC, a continuance might be the good way to do it. Under the Model Business Corporation Act, they've actually adopted this procedure. Wyoming was the first state to have this continuance procedure that maybe none of you have ever heard about, but I wrote a law review article about it a mere 23 years ago, so we've had it for a while. It's an English concept, British concept. The Model Act, as it now stands, as proposed by the business section of the ABA, has the same concept in it. They call it domestication. It's not what I consider a true domestication. Back in the old days, 100 or 150 years ago, a domestication was a way an entity would create a second domicile. Now, the Model Act describes it as a way of changing domicile. But that is a possible method to bring these entities into Wyoming and have them become an LLC. The primary way, I suspect, though, is the conversion method. I'll suggest you take a look at the statutes. We actually have two different sets of statutes with different procedures to do it. I like the simplest statute. I think it's 17-26-101, which just says any kind of entity, foreign or domestic, can turn into any other kind of entity, foreign or domestic. Just file articles of conversion. And I think to be safe, you may want to comply with the conversion provisions you also find in the Limited Liability Company Act statute. But that really is almost like waving a magic wand over the corporation and saying, poof, you're an LLC now. You do have to file articles of conversion that become, in effect, your articles of organization for your LLC. The old entity having changed itself into an LLC. So I would commend that maneuver to create the status of LLC so that we can then be in position with our LLC to become a partner in a partnership. Jim, so you want to talk about payroll facts, maybe?
Sure. On the, I would also sort of set up the quandary that exists in relation to S corporations. Distributions from an S corporation to a shareholder are not subject to self-employment taxes, whereas wages that are paid to a shareholder employee are in fact subject to employment taxes. And it's the first 106,800 of wages in 2011. This year. Yeah, and last year too. Actually, it didn't change. That is subject to self-employment taxes. S corporation employee shareholders, because of that, you all know that, I think, are induced then to try and say, we want to have a low but reasonable salary. Why? Because the lower you push the salary, the less the employment taxes are. And thereafter, if you take your distributions out of the corporation, the S corporation that is, they are theoretically not subject to self-employment taxes. However, and I have a number of cases for you in my paper, which you can go over at your leisure, but I will mention one case. And it's the most recent one, which is Watson versus the United States. And in 2010, the district court decided the case, and the taxpayer was a CPA and a shareholder of his S corporation. And the S corporation itself is a 25% shareholder in an accounting firm. And that's a lot like what you're describing. And during 2002 and 2003, the accounting firm income exceeded $2 million in gross revenue, and the taxpayer worked 40 hours a week, probably more, I assume. As the sole shareholder of the S corporation, the taxpayer set his annual compensation, and here's your numbers for you, in 2003 and 2002, at they set him at $24,000 for both years. Okay, so here's what's going on. They're just saying, I want a low but reasonable salary, and I'm going to set my salaried income at $25,000. Why? So I can pay very little in the way of employment taxes. And the spread between the 108 and the 106, 800 and the 25 would be what you're looking at there. The IRS comes in, they have an expert. The expert basically compares other similar accounting firms with similar value and assets, similar numbers of people, and they say that the accounting firm is underpaying the shareholder as an employee by 300%, and their profits are about 300% too high. Okay, so what do they say? Obviously, they go back in and recharacterize it. They say that effectively, instead of being around $25,000, they're going to add another $70,000 to their incomes, and so, or to this individual's income. So they're going to hit basically the limit, and they're going to pay all the employment taxes. Now, here's the issue. If that's the S corporation employment tax scenario, and if you go back in the cases that I wrote up, most of the taxpayers are losing now. They're not giving themselves reasonable salaries. And so if you have a situation where you're going to say to your client on choice of entity, let's form an S corporation, okay, fine. There's a reason for doing it there. You might be able to beat some of the system by paying a reasonably low salary if you don't get audited. But Tom has brought up the whole charging order example. For example, the whole charging order benefit of having an LLC, right? And so if you have an LLC, the better asset protection rules are sitting there in the new act for you. Now you're going to tell your client, well, gee, it's a better idea to set up an LLC. On top of that, there's a lot of other good reasons to set up an LLC. You have the flexibility of the operating agreement. You can do special allocations. You can do all kinds of things, right? Some people don't like writing up the operating agreement.
But not as an S corporation.
Initially,
Special allocation.
right. The S corporation itself wouldn't allow you to do a special allocation, but you might set up an LLC for those reasons. So the actual problem is you have a quandary. Tom has the solution for you. He's just kind of gone over part of it, I think. But basically, how do I have the benefit of the charging order that get the tax benefits, for example, the employment tax benefits, of an S corporation? Well, why not both? Why not, as Tom, I think, just pointed out, my pointer's not working, form a Wyoming LLC and elect to treat it first as a corporation for federal income tax purposes. It goes back to the check the box rules. You're allowed flexibility if you have an LLC to then file with the IRS to elect to treat it as a corporation. Further on, and you're gonna file it Form 8832 to classify it as a corporation here, and then you're gonna file 2553 to elect S corporation status. Okay, and the outcome is that you have an LLC for state law purposes, but you have an S corporation for federal income tax purposes. And then coming back to Tom's comment, very obviously, in order to remain an S corporation for federal tax purposes, the LLC itself has to abide by the S corporation rules. You have to maintain a certain number of shareholders. You have to be a domestic corporation, and it's 100 shareholders that you need. You have to have, you can't be an exempt organization, or you can't be some sort of other corporation. You have to be an individual. And you have to have only one class of stock and certain other ineligible aspects of that might otherwise disqualify it as an S corporation have to be paid attention to. You have to abide by the S corporation rules. And so the existing S corporation itself, this what Tom is referring to as a conversion or merger, was dealt with in these private letter rulings, where the IRS ruled that upon conversion of an S corporation to an LLC, the original S corporation's S election will not terminate as a result of the reorganization. Okay. Now, this conclusion was supported in Revenue Ruling 64-250, where an S corporation was reincorporated, and Tom was referring to reincorporations a minute ago, in a state other than the state of original incorporation, and this transaction also qualified as a 368A1F reorg. Now, for those of you who are not code people, if you reorg under 368, it's tax-free. It means that effectively the S corporation would realize no gain or loss. The transfer basis of the assets would go into the new entity, and the members would take the new shares with those same old bases, and you'd have carryover of holding periods. And importantly, at the end, the LLC would retain the taxpayer's previously assigned identifying number. So putting that together, what does it mean? It says, Tom's right. You take an existing S corporation, you may wish in Wyoming to convert it into an LLC for state law purposes, mind the S corporation rules, and Private Letter Ruling 2005, 28021, and 48021 support the notion that it's tax-free, that you retain the same identifying number, meaning the same tax number. At the end of the day, you have a tax S corporation and a state law LLC, and you get to take advantage of the employment tax benefit if you can convince the IRS you're being paid a reasonably low salary, and you also get to take the benefit of, for example, the charging order. But you do not get to specially allocate, because if you did that, you'd be outside the S corporation rules. Right.
So on the case law that stands for the principle that pigs get slaughtered, the piggy bank, though, still won't be broken if you pay a reasonable salary, even if that might be less than what the partnership is actually distributing. That $106,800, actually above that, to infinity, is another 2.9% Medicaid tax. So there's always something to be saved. And what my S Corp, my LLC S Corp is doing is keeping the difference between my reasonable salary and what I'm getting from the partnership. And as it builds its capital, of course, the argument becomes with the IRS, well, this partnership has a lot of, this S Corp has a lot of capital, it's entitled to its own return. And so it could be, I think, somewhat self-perpetuating.
I think Tom is right. He's making a very good argument, and this is the argument you want to use if you are pulled in. And that is to say that income is earned in this country on two different aspects. One is that, like me, I'm a wage earner, right? And if my wages that I earn are subject to these self-employment taxes, well, I ought to pay them. That's what the law says. But there's another group of people in society in the United States that earn their income from capital. They earn very little of their income from wages. And Tom's argument goes right hand in hand with that. When the LLC builds up, or an S corporation for tax purposes builds up a substantial amount of capital, it can be argued that whatever is being earned above the reasonable salary is not due to my hard work. It's not wages, and you shouldn't take it from me in the form of employment taxes. Rather, is being earned through the use of capital, and that specifically is not employment taxed.
Except, that's the one unfairness with partnerships, is a heavily capital-intensive partnership that you're a service-providing partner. Your share of the profits is going to be earned income, right? You can try to declare yourself a salary, but all the profits are going to be called earned. So you have to do something like this to protect yourself from the unfairness.
Or stated otherwise, he's saying this self-employment or the employment tax regime is more fair than not having that situation, right? That partnerships are an unfair tax disadvantage.
There you go. Talk about single-member disregarded entities, and we may have to wrap it up.
Well, single-member disregarded entities in the sense of what?
Let's see, I guess maybe we've covered most of that. So for the asset protection, it doesn't need a tax ID number.
Right. From a perspective of a single-member entity itself, as I said, the check-the-box rules will default the single-member entity into a disregarded entity that's reported on your 1040. And the 1040 has your Social Security number on it, not your own, not a separate but different EIN number that would go along with the LLC. And so from that perspective, I think you were going to add to the asset protection part of it? Or?
Well, I think what I've already said is the wisdom of it comes from the fact that it's really completely tax neutral, requires no special tax reporting. You just put an LLC wrapper around an asset, and you may gain some protection by doing that. The only paperwork involved is your annual report to the Wyoming Secretary of State. So that's a very common and now more common technique under this new Wyoming Act. Do we have any questions? All right. Well, in that case, I think we're going to take a break, are we not?
Sure.
And when we come back, Professor Dell will tell us what he thinks about some of our techniques and some of the business transactions that your clients